All right, this morning we have 3 cases, and we will start with Munganga versus Iowa Workforce Development, 25-0122. Mr. Feltus, you will be arguing, and Ms. Kissell will be arguing. Hi. She used to clerk here. Nothing against you. But anytime you're ready, we're ready for you.
Dan Feltus, Iowa Legal Aid. May it please the court. It's great to have the opportunity to be here on behalf of Mr. Munganga. Mr. Munganga, like a lot of low-wage, blue-collar workers, had to work multiple jobs to make ends meet for him and his family. And it suffered periods of underemployment and unemployment, including at the height of the pandemic in response to the COVID-19 virus. Whirlpool laid him off. He filed his claims. He didn't really know what he was doing. He filed his claims to the best of his ability. And as the EAB further concluded, in that case, he worked in good faith to file his claims, and those CARES Act benefits, that overpayment was waived. Later on in 2023, which is the overpayment liability proceeding that is before this court, he again filed in a period of underemployment, and he again messed up his claim. He again was not told how to file his claim. None of the information, including the critical claimant handbook, which lays out the rights and responsibilities, including the difference between gross wages and net wages, including the reality that you got to claim for all jobs, that was never explained to him. The handbook was never translated to French. The Babel notices were never in French. Credit to Iowa Workforce Development, they're now in French. The systemic nature of this case is now resolved. It's very much a...
How were they to know that they needed to do that in this particular case?
Thank you, Judge Greer. Here in this particular case, the record is replete with Mr. Munganga communicating in Google Translate, communicating in French.
How would Workforce Development know that he was using Google Translate to send his information in?
Well, some of his emails, Judge Allers, was in Google Translate, emails and correspondence with Iowa Workforce Development. Mr. Munganga also testified repeatedly that even at the onset of his claims that he testified that he wanted French. He wanted things explained in French. Now, of course, Mark Anderson, the witness for Iowa Workforce Development, said there wasn't an annotation or flag in the system, but of course, Mr. Munganga cannot control who puts the flags in the system, and Mr. Munganga was trying his best throughout to navigate the system. The handbook, in particular, lays out the rights and responsibilities. It lays out especially how you have to file your claim. He never had that available to him in his French.
You have a language barrier issue, right, or a due process problem because of a language barrier. Somebody's been shorted something. They didn't get something that they were entitled to receive. So we can give them a do-over and say, hey, let's do this over, and then let's, with no time deadlines, let's just start the process over and work it through to get the result that you wanted, right? If we did a do-over here, your guy got all the benefits that he was entitled to, correct? And then some.
Correct.
Okay. So we can't really give him a do-over, because if we give him a do-over, he's not going to get any more benefits. He wasn't shorted anything, right? Okay. So how has there been a harm then if he got everything that he was entitled to despite the language barrier?
Well, the harm, Judge Allers, is ongoing. He gets overpayment collections notices every month. His state income tax refund is going to be taken until this overpayment liability is resolved. And also future claims for benefits are going to be offset by this overpayment liability. So again, he's a low-wage blue-collar worker. In all likelihood, he will file in the future. He will lose work, and he will need unemployment insurance in the future. So he's continuously harmed, not just in state tax refund he's being collected on every month, but also in terms of future unemployment. This is an overpayment liability proceeding. This is the proceeding to challenge it. I understand there's one state statute, but you have 3 avenues to grant relief to Mr. Munganga. You got due process as applied. You got the agreed upon rights in the Snyder stipulation to clearly explain rights and responsibilities and consequences. And you also have Title VI. Specifically, on due process, the Schulte case, which we cite on page 20, Minnesota Supreme Court case, says, and I quote, "Without knowing the specific consequences of proposed government action, a person cannot make an informed choice." And the key in that case, and then in the holding, the court goes on to talk at length about informed choice. Mr. Munganga never had that opportunity to make an informed choice about how to interact with the system, because the key bedrock of explaining the rights and responsibility, the handbook, was never afforded to him in French. The Snyder stipulation says you have to clearly explain rights and responsibilities. Handbook, not in French. It was never clearly explained.
Bolstered by the Department of Labor letter, which kind of mandated that as soon as the agency is aware that they should convey the information in that language. Is that kind of part of this whole situation?
Yes, absolutely. And that goes directly to not just due process, but Title VI as well. And under Title VI, there's also the CFR that makes it very clear. This is 29 CFR 38.9B. A recipient, that being Iowa Workforce Development, a recipient of federal funds, must take reasonable steps to ensure meaningful access to each limited English proficient individual served or encountered. That didn't happen here. Now, again, the systemic issues are resolved. It's in French now, the handbook, the Babel notice is in French. There's 10 other languages in French in the handbook online. And so right here, it's really just about relief for Mr. Munganga. And there's 3 avenues to grant that relief.
Well, I was just thinking, this kind of takes me back to as soon as the agency is aware. So I'm still kind of tripped up on when did they first become aware?
So there's a couple different ways to address that. Number one, we think they were aware throughout. We think, because Mr. Munganga testified to that, the fact that there wasn't an annotation or flag in the system doesn't mean that they weren't aware. So 2 things can be true at once. It could be that the appellee's witness testified, I didn't see an annotation, and also Mr. Munganga, who clearly speaks French, spoke French and requested French, and that was unrebutted. And even in Appellee's brief, they don't attack his testimony that he requested French throughout. So notwithstanding that, there's also the should have known analysis. That's the Talamantes case. So in Talamantes, it says knew or should have known that the person needed this assistance to have the rights and responsibilities clearly explained. And that then, obviously it didn't happen here, and they should have known that Mr. Munganga, who was interacting in the system in French the entire time, didn't have the explanation to him in the handbook. Now, it is interesting that the handbook, which is pointed to often, or overpayment liability proceedings and pointed to here, is only mentioned once in the appellee's brief, and that's on page 39 of the appellee's brief. And they say, well,
Authority for your proposed remedy of just basically forgiving him the obligation to repay, when we have a statute that specifically says good faith doesn't matter. If you're overpaid, you owe the money back. What's the authority that would allow us just to wave a magic wand and say, we absolve you of that repayment obligation?
well, 2 things. One is obviously due process as applied is a higher authority than the state law. The Snyder agreed upon due process stipulation is a higher authority, and also Title VI and corresponding regulations. But notwithstanding that, in addition to that, Iowa Code 17A 1910, 17A 1910 says this court may affirm the agency action or remand to the agency for further proceedings. The court shall reverse, modify, or grant other appropriate relief from agency action, equitable or legal. Equitable or legal. So legal or equitable, higher legal authorities, but equitable as well. And you don't need to have some sort of underlying equitable theory. It's laid out in the statute. There's specific provisions that we pled under 10. A, B, and C in particular are at issue in this briefing. But as the Krieger case points out on page 39 of our brief, we cite the Krieger, much different situation. But Krieger says, in a petition for judicial review, you have broad authority to grant equitable relief, but it's not an equitable proceeding. So the equitable relief is don't collect. It's a very individualized situation here. Stop the collection on Mr. Munganga. He's prejudiced by the collection. continues to be prejudiced by the collection, will have his state income tax refund taken until it's resolved. He will be prevented from getting unemployment insurance moving forward, and it's just not right. He did his best throughout. The broad issues have been resolved. Fundamentally, I think what the appellee is asking this court, though, is to say that there's no accountability. There's no accountability for not doing the right thing for Mr. Munganga. And our accountability, Your Honor, is to make sure that he doesn't have to repay that overpayment. Thank you very much.
Thank you.
May it please the court, counsel. My name is Hallie Kissell, and I represent the Appellee-Iowa Workforce Development. Now, this court can't provide a remedy for Mr. Munganga because of how he chose to bring this action. He brought a 17A action to review a specific decision, the overpayment decision. Under 17A 1019, this court can reverse, remand, or modify if someone's substantial rights have been prejudiced. That has not happened here. Chapter 96 is clear that no matter the fault of an overpayment, it must be paid back. Nowhere under Chapter 17A is someone's remedy that they get to keep their overpayment, which is what Mr. Munganga is asking for here.
Argument that the kind of catch-all, you can reverse, remand, modify, grant equitable or legal relief, why doesn't that give him an opening to have the repayment obligation forgiven?
Yes, Your Honor. I think because of the language that follows, yes, it says you can reverse, remand, or modify if there's been prejudice to substantial rights. And here Mr. Munganga wasn't prejudiced, and I think it points to what you were asking earlier about if we go back and do this over and give Mr. Munganga what he wants, which would be the handbook provided in French, there's two options. Either he doesn't get overpaid, or he does get overpaid and has the benefits again. And so either way, the ALJ's finding of that Mr. Munganga isn't entitled to the extra $5,000 in benefits is the same. And so Mr. Munganga can't show prejudice here to prevail under Chapter 17A.
What about his argument that because of the ongoing collection efforts, his ineligibility for future unemployment benefits, those types of things, why aren't those harms that have prejudiced him?
I think because, Your Honor, the statute is clear under Chapter 96.37A that if there is an overpayment, it has to be paid back. And so we're just looking at the money that Mr. Munganga was given here. And the legislature has made it clear that if an overpayment occurs, no matter the fault, it has to be paid back. So there can't be shown prejudice to Mr. Munganga keeping that money here. And so the only questions that are before this court are whether the overpayment violated his right to due process and whether IWD somehow violated Title VI by not providing unemployment materials in French. And before
Yeah, that we wouldn't even be here if he had had the information in French so that he wouldn't have been tripped up the way that he was.
Your Honor, two things to that. We would be here still because the ALJ's factual findings, Mr. Munganga does not assert that they aren't supported by substantial evidence. And if they don't, then that means that they're binding on this court and Mr. Munganga on appeal. And so in the ALJ's factual findings, they found that IWD was not aware of Mr. Munganga's French preference. And so we're bound by that finding that they weren't aware. But also, for due process, the two requirements are that there has to be notice and an opportunity to be heard. And notice just has to inform of the issues involved in order to prevent surprise at the hearing. That's from the Oscar Mayer Foods Corp case, as well as it has to be reasonably calculated to apprise the interested parties of the action against them. And so because Mr. Munganga is appealing the overpayment decision, that is the only agency action that could implicate due process here. And
Preservation on Title VI. I didn't get a chance. I ran out of time to ask Mr. Feltus about that, and that's the only hint I'm going to give you for rebuttal argument. Can you talk about air preservation on that?
yes, Your So for Title VI, it wasn't preserved here. The ALJ never ruled on it, and there was no motion for rehearing. And so the case law is that appellate courts may review only issues that were considered and decided by the agency. And if an issue is raised and the agency doesn't decide, then a motion for rehearing has to be filed. And that's from the Arbor Court case from this court, as well as the KFC Corp case from the Iowa Supreme Court. And so here, the Title VI issue was raised before the ALJ, but the ALJ never addressed it, and there was no motion for rehearing. And we will note that the staff management case that Mr. Munganga cites does say that it just has to be raised before the agency, but if you actually look at the case that case is relying on, it's the Office of Consumer Advocate, 46-5 Northwest 2nd 280, and that concerned a constitutional claim. And we agree that constitutional claims only have to be raised before the agency, not ruled upon, because the agency doesn't have the authority to rule on a constitutional issue. But Title VI is a statutory claim, and the case law is clear under KFC and Arbor Court that a rehearing motion is required to preserve error. As well as the cases that were cited in reply that we're talking about a motion for rehearing not applying in administrative context, those were all dealing with exhaustion, and if you have to file a motion for rehearing to exhaust your remedies, we've never contested that Mr. Munganga didn't exhaust here, so those cases don't have any merit here dealing with the error preservation.
Your opponent indicated the CARES overpayment was waived, unlike the fees we're talking about here. Was that waived on an equitable basis, or why was it waived?
Your Honor, I'm not exactly sure what the CARES of fees was waived for, and I believe that was with the 2020 claim, and we're just looking at the 2023 filing issue here, so I don't think that that has any basis in your decision here.
The only reason I ask that is you've indicated in your briefing that an equitable remedy is not available for this overpayment. I'm just wondering if it was the reason for the CARES waiver.
Your Honor, I will say that in our briefing, I think we do say that equitable relief can't be granted, which I think might have been a misstatement, because I do think there can be equitable relief under the statute. But what Mr. Munganga is asking for here about keeping the overpayment, that's not appropriate equitable relief. And Mr. Munganga hasn't pointed to anywhere in Chapter 76 that would give him that relief. And I do want to point quickly back to the error preservation case, specifically because I mentioned Arbor Court, and I know Judge Greer, you concurred in that, saying that you would have found error was preserved, but I think we can distinguish the facts of that case, and if I'm summarizing your concurrence correctly, that there the ALJ really kind of utilized both arguments, and while he didn't rule on one, it was still like implicit in his ruling. And here, the ALJ doesn't mention Title VI or any of its regulation, and so I think we can distinguish the facts there and find error wasn't preserved. But even if this court were to find error was preserved, again, there's no prejudice, and it's the same analysis for the due process as the Title VI, that even if we assume that a Title VI violation or due process violation happened, it has no effect on the outcome. Mr. Munganga was overpaid, and repayment is mandatory. And also for Title VI, it would fail for another reason, and that's that this claim is outside the scope of this proceeding. The final agency action under review is the overpayment decision. It is not IWD's broader communication practices. So Mr. Munganga points to 17A, 19, 10, B, and C, which says a court can reverse only if the final agency action exceeds the agency's statutory authority or is based on an erroneous interpretation of law. And here the overpayment does not implicate Title VI. He does not claim the overpayment decision itself violated Title VI or its regulations, and so he cannot demonstrate that the final agency action violated Chapter 17A. There's also no violation on the merits of Title VI, and we believe that's the final reason for why this court could affirm the Title VI issue. Title VI prohibits only intentional discrimination based on national origin. Here, Mr. Munganga never alleges intentional discrimination. The word isn't in his brief, as well as when he's talking about language, language does not equal national origin under Eighth Circuit precedent. And going to the regulation that Mr. Munganga points to, 29 CFR Section 389, it does say that the agency must take reasonable steps, but those steps are flexible. In 29 CFR 38.9B1. It says reasonable steps generally may include, and the appendix also says, talks about elements of a successful language plan, how they're not fixed, and they have to be tailored to each agency.
The agency's position that, or your position that there's nothing in this record that points to the fact that the workforce development people should have known that French was his language?
Your Honor, I think two answers to that. One, again, we're bound by the ALJ's factual findings, and there they found that they did not know, IW didn't know. But I don't think that the standard is correct, that it's about if they reasonably knew. That would be the Talamontes case that is mentioned. But there, that was a district court case where they create this test kind of out of thin air. There's no case cite to it. So I don't think it really comes into play whether they reasonably should have known or did know. I think we look at what was provided under due process, which is you're supposed to look at notice and opportunity to be heard. And here, Mr. Munganga got both of those. So there was no due process violation or violation of Title VI. So we would ask that the district court, that this court would affirm the district court's ruling.
Rebuttal?
Guess what I'm going to ask you, Mr. Feltes?
I'm in Judge Allers.
Lay it on me. What do you got on the air preservation issue?
A few things, Judge Allers. First, if you look at page 8 of the ALJ's decision, the ALJ says, Iowa Code 96.3, so on and so forth, states clearly I cannot consider claimants' good faith mistakes, whether they be due to English proficiency or otherwise. So, sure, the ALJ didn't say Title VI, but it seems as though the ALJ was considering the English proficiency arguments, which we clearly raised in a pre-hearing brief, not just at the
Claiming you didn't raise it. I think the problem is, or the claim is that the ALJ didn't rule on it, and you have to ask for a rehearing if that happens. That's the argument anyway.
Judge Allers, I think that you could argue that the ALJ did rule on it by saying English proficiency in it. But if you want to get to, Your Honor, if you want to get to the argument raised on waiver, only on Title VI, by the way, there's not an argument about waiver of due process or Snyder. In fact, they agree they're bound by Snyder and that sort of thing. But Jimenez and Ellis control. Those are the controlling precedent. Those weren't even mentioned in Appellee's brief, the Jimenez case and Ellis. If you raise it before a final decision of the ALJ, you've raised it. You can lead a horse to water, but you can't force it to drink. You can only raise things so many times, before a fact finder. In terms of equity,
Are those cases exhaustion of administrative remedy cases, or are they air preservation cases?
I think they're a little bit of both, Your Honor. And in fact, Jimenez concludes that you have to raise it before the final decision, and Ellis talks about it being optional for an application for rehearing. In fact, the statute is very clear. It's optional to make an application for rehearing. The Arbor Court...
True in exhaustion of administrative remedies, and as opposing counsel indicated, they're not claiming you didn't exhaust administrative remedies. So I agree that you don't have to ask for rehearing to exhaust, but I think you do have to ask for rehearing to ask the ALJ to rule on an issue that it didn't.
Judge Allers, well, we can't force an ALJ to write words in their decisions, right? Now, the Arbor Court case, which is the key case that Appellee cites, that was brought up on a petition for judicial review, challenging the legislature's change to the Medicaid reimbursement rates mid-proceeding. And I would agree with the Arbor Court case. In fact, but Jimenez and Ellis talk about raising it before a final fact finder decision. We did that. And so I think it's very clear that we raised it. And, you know, I've filed lots of applications for rehearings and motions for rehearing, and usually it's just one word, denied. So
With you, that you can't force them to rule, but I mean, if you say, hey, look, you didn't address the title, you file a petition for rehearing saying you didn't address the Title VI claim, and if the judge just says denied, yeah, I agree with you. There's nothing more you can do at that point, even though that didn't get you any further down the road for an analysis than not raising it, but at least you jumped through that procedural hoop.
There's nothing in the statute that requires it, and the statute is optional in an application rehearing. The statute doesn't say, the legislature doesn't say, if they don't specifically say the words of your argument, you have to ask them to specifically say those words. The statute doesn't say that. It's completely optional, and notwithstanding that it does mention English proficiency in his decision. On equity, Judge Schumacher, you asked the question about the waiver of the CARES Act. The standard is good faith, and repayment would be against equity and good conscience. And the Employment Appeal Board decided it would be against equity and good conscience to require Mr. Munganga to repay. So here, again, he messed up his claims, no doubt about that. He was never clearly informed. The relief we're requesting is that this mandated overpayment in this proceeding, this is the proceeding to challenge overpayment liability. This is a proceeding. We're asking this court to grant legal or equitable relief for Mr. Munganga that he doesn't have to be forced to repay this. He doesn't have his state income tax refunds taken. He can be eligible in future job separations for unemployment. He doesn't get the monthly collections notice. He's not under constant fear of this. He's a low-wage, blue-collar worker. He's trying his best. We're not asking for a broad sweeping ruling. I think a ruling for Appellee would be broad and sweeping, that they don't have to be accountable to their agreed-upon obligations under Snyder, that they don't have to comply with due process in the weekly processing of claims, and that they don't have to be bound by Title VI. So we really respectfully appreciate the opportunity to be here, and we encourage you to issue a decision negating the requirement of repaying this overpayment. Thank you, Your Honor.
Thank you. Counsel, thank you for your arguments today and the good briefing. We will consider 250122 Munganga versus, and I'm never going to do that right, versus Iowa Workforce Development, and we will consider that submitted, and we will get a decision out to you folks as soon as we can. Thank you.